Good day or good night, depending on where you're tuning in from. I am delighted to welcome you to another session of Africa in the Moot's Open Access Education Series in the context of the 32nd Willem C. Vis International Commercial Arbitration Moot. Need to take a breath. I am Erin Cronje, a director of Africa in the Moot and an international arbitration practitioner qualified in South Africa. And I am joined today by the very lovely Deputy Chair of Africa in the Moot's Education Committee, Ms. Khara. If you have tuned in to gather more intel about the Finnish rules of arbitration as a practitioner or to sharpen your arguments as a FISMoot participant, but you don't yet know what Africa in the Moot is, allow me to sneak a moment to tell you exactly what it is. It is a non-profit, volunteer-based organization which supports sub-Saharan African teams to participate in the FISMoot. So you might know, if you're here, that the FISMoot is the largest commercial arbitration moot competition in the world, and it typically draws hundreds of teams. I think at last count it was over 500 in total from around the world to compete. But unfortunately, sub-Saharan Africa's participation has been less than 1% of that in the past 3 decades that the FISMoot has been running. But at Africa in the Moot, it is our very motivated objective to change that. So over the 8-month FISMoot journey, we are giving support to a community of wonderful teams from sub-Saharan Africa through coaching, training, an education series such as this one, access to resources and funding. And this is now our 4th year of operation, but we're very, very proud to be supporting a community of 19 teams, which is a new record for the FISMoot. So please also do keep a lookout for these teams on social media, at pre-moots, and then hopefully in person in Vienna or Hong Kong. And please also follow our social media as we host the East Africa Pre-Moot in Nairobi, Kenya in February each year, which is an award-winning event and the only event of its kind in the whole of sub-Saharan Africa. And you are all invited to apply with your teams for a slot to hopefully participate there too. But now that's Africa in the Moot's place in the FISMoot and its spot in the world per se, but turning to the very global nature of the FISMoot itself and international commercial law and international arbitration, we are privileged each year to take a trip around the world per se and to look at different jurisdictions and different arbitral institutions. And you may be wondering as you work through the problem, or perhaps as a young practitioner who's new to arbitration, what is an institutional arbitration? What is an institution? Why does it matter? Why do institutions have different rules? And also, how can these be applied to your legal dispute? Well, today we get to hear directly from the source, as we have the honor to be joined by Professor Henrik Sajakorpi, who is the Secretary General of the Finland Arbitration Institute, which is, of course, the custodian of the Finnish rules of arbitration, which apply to the 32nd FISMoot. Now, in his role as Secretary General, Henrik is responsible for coordinating and developing domestic and global activities of the Finnish Arbitration Institute, also known as the FAI, in cooperation with the FAI board. And he formerly practiced dispute resolution, including international commercial arbitration, at Rochier Attorneys Limited, which is a leading law firm in the Nordic region and ranked in the Global Arbitration Review's 100. And also, very pertinent, I think you have a good comrade for those who are delving into the claimants and respondents memos at the moment, because he also did the FISMoot, so he knows the experience from that perspective very well. Now, it has been a very, very busy moot season for him and his colleagues, because as you can imagine, all of the representatives of the Finnish Arbitration Institute are very in demand for their insights on the procedural matters arising from this year's moot problem. And while he cannot give you any direct answers, I believe there's, contracts and non-disclosures and all of that. But I do hope that his presentation will answer some of your questions and assist you in your preparations as a mootie or a young practitioner getting into this world of arbitrations. So if you have any questions, please feel free to drop them in the chat at any time. There will be time for a short Q&A at the end. But with that, I hand over to Henrik with thanks. Over to you.
Thank you very much, and good morning, good day, and good evening to everyone. It's a pleasure and a privilege to be here today. I mean, it's always nice to be talking about the FAI arbitration rules, but it's even more nice to be talking with a FISMoot audience. I mean, as Erin already introduced me, I'm also a FISMoot alumni myself. I did the FISMoot 10 years ago, so I'm very much familiar with the FISMoot, and I've coached FISMoot teams for 4 years. in my earlier career. So I know what you have ahead of you, and I'm very privileged to be part of your Vismoot journey. And I hope that the presentation that I've prepared for you today, and which I will help today, will be of benefit for you now that you're preparing for the written phase of the Vismoot. But perhaps now, excellent. So now we have or you should have ahead of you the actual presentation. So I have the Herculean task of holding a presentation on the Finnish rules of arbitration and the FAI arbitration rules, and I have 45 minutes time basically allocated for this presentation. So obviously I will not go into every possible detail and explain you the bits and pieces of every FAI arbitration like provision. But what I'm trying to do here today is go through those that might be of special interest to the Vismoot audience. So what you see here now in front of you is the structure of this presentation. So I've really structured this into 4 main segments. I will start by giving you an overview of us, so the Finland Arbitration Institute, so that you really know who we are and what it is actually that we do as an arbitration institute. Then I will discuss on a very high level the FAI arbitration rules, or more likely describe them. And then we'll move to the actual topic of interest potentially for many of you in the audience, so determination of jurisdiction. But I will focus here on the determination that's done by the FAI board, because I will be holding this entire presentation from the viewpoint of the Arbitration Institute. So I will not venture very far into the realm of the arbitrators and their decision making. And if time allows, I will conclude by just giving you a quick glance on issues such as the transmission of case file, as well as admissibility of evidence, both themes that are relevant for this year's Vismoot case. But having said this, let's start. So section 1, the Finland Arbitration Institute. So who are we actually? As our name suggests, we are an arbitration institute. So we started our operations already in 1911. So we're quite an old institute, actually. We were founded in Vaasa, Finland. That's in the west coast of Finland. And just by looking at the year that we were established, we're also one of the oldest still operating arbitration institutes in the world. We were originally established to handle disputes that relate to or foreign trade type of disputes, such as like product quality issues. But nowadays, our range of commercial disputes that we administer is much broader. Arbitration rules are the first ones. The first ones were drafted in 1910, but of course they've been constantly updated thereafter. And the first, let's say, full revision took place in 2013, and it's actually as of that point in time that I can say with confidence that our rules have been on par with best international practices and standards. As an arbitration institute, we are part of the Finland Chamber of Commerce, but at the same time, we are completely independent of it when it comes to decision making. And also our office space, our files and information, that's restricted only to the FAI staff. In terms of organization, just to give you an understanding of this as well, I mean, we have a threefold organization in a sense. We have the FAI board, which comprises of 16 board members, both Finnish board members as well as international. with all of them having like distinguished legal backgrounds and expertise. Then we have the FAI Secretariat, to which I also belong to. I lead the Secretariat, and we have a team of 5 qualified lawyers now, plus 1 legal assistant here. And then, like every other type of institute, basically, we also have, I need to have like support functions that assist us in events and marketing. Very important as well. But now that you know who we are, in a sense, let's quickly discuss what it is that we then do here. So our core task is or relates to obviously arbitration, but also to mediation. And more specifically, we administer arbitrations and mediations, both domestic and international. And for this, we have 3 separate rule sets. And I'm pretty sure that you're all familiar with them since they are referred in the Moot case or the problem itself. But anyhow, I mean, we have the standard arbitration rules, we have the expedited arbitration rules, and then finally, we also have the FAI mediation rules. Now, I already mentioned that we have the FAI board that's separate from the FAI secretariat. Now, in terms of like division of work here at the Institute, the FAI board, they make decisions under the FAI rules, as well as, of course, the FAI mediation rules that relate to issues such as determining the seat of arbitration, making prima facie jurisdictional decisions, addressing challenges to arbitrators, consolidating cases, deciding on joinders. So these type of things, these are, of course, all discussed in the rules themselves. Now, we, as the Secretariat, our task here is really to perform daily administrative functions related to arbitrations and mediations. And what we also do as part of this work is that we prepare decisions for the FAI board. But in addition to these core or main tasks, if you will, we also have some other tasks that we also deal with constantly, and I have them here on the slide. So there's basically like 3, if not more, these that are worth mentioning, really. And one of them, or the first one here on the slide, is the appointing authority task. What this means basically is that the FAI acts as an appointing authority in arbitrations that are conducted or not conducted under the FAI rules, but are so-called ad hoc arbitrations. So even though an arbitration isn't like administered by us, if the parties have so agreed upon, we can nonetheless, in that specific arbitration, appoint the arbitrator or the arbitrators. Then, additionally, we are heavily involved in education and also in organizing events. Just recently, we organized this like FAA arbitration masterclass for experienced arbitration practitioners here in Finland. We have FAI Arbitration Academy for those that are just entering into the field of international arbitration or domestic arbitration, or have been there for a while. I mean, we have different types of programs, but we also arrange seminars, support the study of ADR, including arbitration, specifically also through our collaboration and contribution to the Moot, and specifically, of course, also this year. And then we host professional events, like key arbitration events for the arbitration community. And I specifically want to pinpoint one of those events called HIAD, or Helsinki International Arbitration Day. So that's something that we arrange here in Helsinki, Finland, every second year. And it's always on a topical theme of international arbitration. And actually, the next HIAD will take place approximately a month after the oral finals in Vienna. So if anyone of you wants to visit Helsinki in May, then now you have a perfect opportunity for that. And finally, one task that we also have is like the general promotion of ADR. I mean, we arrange different types of, let's say, road shows, company visits, and other initiatives where we go and really try to promote not only the awareness of ADR but also the understanding of it. And these tasks, all these, the main task and these lesser tasks, these do keep us very busy at the institute. Statistics. I couldn't resist myself in not showing you some statistics. I will not definitely go through that picture on the right side, which includes all those percentages there. But I just wanted to give you a certain overview of what our caseload is and what type of cases we have here at the institutes annually. Now, these are like statistics from last year, and these are also available online from our website. So you can check these out later or look them through in more detail if you want. But anyhow, in terms of our caseload, last year we had 71 requests for arbitrations. And out of those 71 cases, 35.2% were these so-called international arbitration cases, as opposed to domestic arbitrations. And in our like meaning, the international case means a case where at least one of the parties is not established in Finland or is not the national of Finland. And parties really like came from all around the world. There were at least 20 different countries where the parties came from. So, I mean, we really attracted parties from all around the world. In terms of like the composition of the tribunals, I wanted to mention out of curiosity, perhaps mostly that 85.9% of the cases that we administered involved only one arbitrator instead of 3 arbitrators. And this has a lot to do, of course, also on the fact that under the FAI arbitration rules, the general rule is that there shall be one arbitrator, like if the parties have not agreed otherwise, and if the FAI board does not decide otherwise. But that's basically a Nordic peculiarity in a sense that you don't need to go far in Middle Europe or elsewhere to notice that in there the use of sole arbitrators is like statistically speaking is not that common. But here in the Nordics it has worked really nicely. For efficiency reasons, I also wanted to mention our like the duration of the arbitrations that we administer. Mediation duration of a standard arbitration, so that was arbitration, I mean, which is conducted under the standard set of rules, that took around 8.9 months on average, whereas a expedited arbitration took 3.1 months. When I'm talking about duration, I mean the duration between the moment when a case file is transmitted to an arbitral tribunal until the award is rendered. But these are really good figures also in international comparison. In terms of like the most common type of contracts involved in disputes, the sale and purchase agreements, so SPAs, were the most common types of contracts involved. Shareholder agreements came second with 23.9%, representing that amount in the overall value. And then thirdly, we had construction agreements in 12.7%, percentage of the cases. But anyhow, I will not bore you with these statistics longer than this. I just wanted to really convey the idea that if you look at these numbers, the FAI arbitration is a very, very fast method for resolving different types of commercial disputes, and that we attract both domestic as well as international cases annually. Now to the second section that concerns the FAI arbitration rules, and here I'm just giving you a overview, or let's say over a description of what our rules are like, but not going into detail of any specific rules here yet. But anyhow, as I already mentioned in the very beginning of my presentation, our original rules were drafted in 1910, but they've been continuously updated thereafter. And the rules that we now have in place, they do align with best international standards. So we have excellent customer feedback and also international recognition. On the slide, I have one of the recent reviews or rankings that we received, in addition to certain other Nordic institutes. I have it on the slide. I will not read it out loud, but I just want to mention that's something that we were, of course, very proud to notice that the Legal 500 were also picking up on the good work that we've been doing here at the Institute. The latest update to our arbitration rules took place or came into effect actually in 1st of January this year. So now those of you attending this webinar who are doing the Moot, you are now then reviewing and interplaying with the most recent rules. And what we did change compared to the other, or the latest, or the earlier version, I mean, there wasn't anything major in a sense. This revision was more of a, well, not cosmetic in nature, but let's say it was more fine-tuning than a full revision. I wanted to make few observations from the revision nonetheless, and there were like three main things that were changed. So first of all, like the cost structures were simplified. I already mentioned that we have two separate like arbitration rules, the standard ones and then the expedited arbitration rules. After this revision, the filing fees and the cost tables that are included in those rules, they were like simplified in a sense that they are now the same. So we apply the same filing fees and the same filing fee tables across both set of rules, just simplifying things really. We also added a new provision on the disclosure of third-party funding, with the intent of further safeguarding the impartiality and the independence of arbitrators. I haven't yet at my time at the Institute seen third-party funding related disclosures. Yet third-party funding is nonetheless still is something that here in Finland there is definitely a level of buzz about. Finally, gender-neutral language. This is something that the Institute does find very important. We have here in Finland, and I'm talking about the Finnish language, we have gendered terms in our language. I mean, the term arbitrator in Finnish, for example, is välimies, which is a gender term and means basically middleman. And when we did this revision, we wanted to get rid of all those gender terms referring to men, and so we changed all those gender terms to more neutral ones. So for example, when I mentioned you earlier that the term välimies, the middleman, we don't use that anymore, but what we have instead is basically middle judge, neutral, and better and in line with the modern times. Similar changes were done with the Swedish language version of our rules, as Sweden or Swedish language does have the same gendered terms structure, I mean, in their language as well. And finally, on this slide, the language accessibility, I just wanted to mention that the rules, and I'm talking about or referring to all set of rules that we have, so the FAI arbitration rules, the expedited arbitration rules, as well as the mediation rules, they come in 3 languages: English, Finnish, and Swedish, with the English version being the prevailing version. But obviously, I mean, the Secretariat, we do give support to parties also in different languages, including Spanish and German. Quickly on other resources that are available on our website and that might be beneficial for you to look into afterwards. To support like arbitration processes, we offer certain documents that give guidance on FAI arbitrations and actually also on FAI mediations. So we have like these arbitrator guidelines on both arbitration and mediation. Do check those out. They include like observations on practical issues, and some of them might be relevant also now that you are preparing for the Moot. But I wanted to really point out that these like guidelines, they are not like additional rules of procedure, and this is actually something that's also stated in those documents themselves. But they're nonetheless, they might be useful also outside of an arbitration. We have our award checklists for arbitrators that they can follow when they're preparing their awards. Then we have also like a note on the use of a secretary, which deals with or gives instructions on the appointment, duties, remuneration of tribunal secretaries, and so forth. And finally, we do provide model clauses, both related to mediation as well as arbitrators, that have the intent of enabling parties to easily agree on FAI arbitration or FAI mediation. But now, having said all this, like general, having given you all this general information on the FAI arbitration and our rules, now I'm moving to the part that I would assume you find the most interesting, perhaps, because this now relates to the themes that are in the core of the Moot as well. We know, and from the Moot case itself as well, that under our rules, the answer to request for arbitration should include, to the extent possible, any plea that the tribunal to constituted lacks jurisdiction. If such a jurisdictional plea is then raised, which does happen quite often, then what we do here at the FAI is we deliver such plea to the claimant and give the claimant then a time limit, which is typically 1 or 2 weeks, between two and 1 weeks, to submit a reply to such jurisdictional plea. And after this stage, then the FAI board will, in its capacity, then make a prima facie determination on jurisdiction. And this is also something that you see happening in the Moot case. So I already mentioned that these jurisdictional pleas are they're not like uncommon. I had a quick look at our statistics when I was preparing this presentation, and I noticed actually that in the past few years we have received jurisdictional pleas in at least between 10 and 15 arbitrations annually. So that's in a sense, quite a lot, I'd say, considering that our caseload, for example, last year was 71. So that's a nice percentage of cases where actually the jurisdiction of the tribunal is contested in the initial stage of arbitration. But once a jurisdictional plea is then raised in the request, in the answer, then it's decided upon by the FI board. But before actually going to the actual test and the procedure, how the FAI board makes decisions on those matters, I wanted to give you a better understanding on these like jurisdictional pleas, what they typically look like. And of course, like they come in different colors and forms, but nonetheless, you can, in a sense, try to place them into different main categories. And this is also what I've been doing here on this slide. So generally speaking, like these jurisdictional pleas, they do relate to the existence of the arbitration agreement, the validity of the arbitration agreement, or to the scope of arbitration agreement. And if we like consider the first main group, if you may, so the existence, here what we typically perhaps could expect to see is arguments such as that the arbitration agreement containing the contract containing the arbitration clause is a draft that was never finalized and that was never accepted by the parties. Or we do see arguments that the arbitration agreement does not sufficiently refer to FAI arbitration or the FAI, so that there's, let's say, a certain difference between the words used or the terminology when referring to us, for example, as an institution. Then the second category, the validity, again, encompasses a lot of different types of arguments and allegations. But here, what you may encounter is for example, allegations that the dispute itself is not arbitrable under the applicable law, so that it cannot be settled by arbitration. Or, for example, that the person who signed the arbitration agreement or the contract that included the arbitration clause, that the person lacked the authority to bind the respondent company. And finally, and perhaps most interestingly, considering the Vismut again, the scope related allegations. Here, what we can see is allegations, for example, that the arbitration agreement was limited to certain types of disputes or certain types of claims, or that the arbitration agreement is inoperable because the claimant failed to comply with a certain like pre-arbitral steps that were agreed between the parties. And in practice, those are like arguments can relate to both negotiations or mediation. And the latter, of course, is something that I understand that the Vismut participants are very much interested in and working with now in preparing the memos. But so what happens if a jurisdictional plea is raised? Now, the Article 15 of the FAI arbitration rules, and I'm now talking about the standard arbitration rules. So that includes the framework for the determination of jurisdiction in these instances. So, and by these instances, I mean instances where the party against whom the claim in the arbitration has been made raises a plea which relates to the existence, the validity, or the applicability of the arbitration agreement. And if there is like only one arbitration agreement, then the FAI board shall allow the arbitration to proceed if it is prima facie satisfied that an arbitration agreement that binds the parties may exist. I will come to the test in the next slide. But this determination by the FAI board, I think it's important to understand that it's first of all it's done on a case-by-case basis, considering all the relevant circumstances, and it's not actually even a jurisdictional decision, but it's an administrative decision by the FAI on whether to proceed with appointing the tribunal and then transmitting the case file to the tribunal. And this is not surprising, also considering the logic of the arbitration rules that we have. I mean, the Article 15.3 of the rules clarifies that the decision that the FAI board makes is not binding on the tribunal, which shall then ultimately decide on its own jurisdiction. So in general, this Article 15 and 15.3 especially, they reflect the well-established competence principle, according to which the arbitral tribunal is empowered, as well as, of course, required to finally determine any pleas raised against its jurisdiction. And like Article 15.3 relates to and should also be read and understood in conjunction with Article 33.1, which again provides very clearly that the arbitral tribunal shall have the power to rule on its own jurisdiction. So it's an interplay, in a sense, between these different provisions. But I already mentioned that the test that the FAI board follows is the prima facie one. But let's go to that a bit more specifically. So the prima facie threshold, and I think this is relatively, or if not very important to understand in the Moot context as well, is that as you can see from the wording of the rules, so the Article 15, I mean, it's a very relatively low threshold, which only requires that the FAI board is convinced that an arbitration agreement may exist, rather than actually, concluding that an arbitration agreement does exist. And that's a big difference already between those two words or formulations. So may versus does. But of course, there are really good reasons for why the decision making of the FAI board is only done has been regulated with the prima facie threshold only. And I already gave you an understanding or like a general impression of what the FAI board does here, and that they are like legal professionals acting in different most of them are actually like practicing lawyers, academia, involved in academia. They have also other tasks and other jobs and what they do. So they're not like full-time doing work at the FAI like I am and the FAI secretariat is. So the rules are not built in a sense or in the way that the FAI board would be equipped or well equipped to very thoroughly examine the merits of jurisdictional disputes. And by this I mean really going deep and analyzing arguments and evidence presented by the parties in detail. So that's just not practically possible. And in the FAI board, they lack the opportunity to allow the parties to provide oral argumentation or oral arguments. I mean, so then what this means is that the FAI board couldn't assess jurisdictional disputes in light of evidence, oral evidence. And already considering these two main points, I mean, jurisdictional disputes that are often very complex and can be very complex, I mean, they are essentially just better left for the arbitral tribunals to assess and decide upon. But this is not to say that the board would not be very thorough in its examination, nonetheless, based on the filings of the parties. So typically it's the answer, and then you would have the comments from the claimants. Of course, the FAI board is very careful in reviewing those points raised, but the test is the prima facie one, and that what that means also is that typically what we see is that the board does require that there's at least some kind of documentary evidence available on the existence of the arbitration agreement for the FAI board to allow it to proceed. But in practice, it's relatively rare to see that the FAI board would find, again, prima facie, that a arbitration agreement binding the parties may exist. And with my time in the institute, I've been here from March this year. I've actually encountered only a very few cases from this and last year where such a negative finding was done. So that just reflects the fact that this is a prima facie threshold, a low one. But I see that we have now basically around 15 minutes left, and that's good in a sense that I have only one slide left, and then we can take questions that you have. But I wanted to touch upon the transmission of case file as well as the admissibility of evidence issue, because these again are relevant for the Moot problem this year. So this is just like a very high level summary on both of these issues, and again from the viewpoint of the institute. How it works here when it comes to case file as well as exhibits, so evidence, is that we at the FAI, we do transmit the case file as it is, including all exhibits submitted by the parties in connection with the request for arbitration, as well as answer any subsequent pleadings to the arbitral tribunal once it is constituted, and once the filing fees and advance on costs have been paid. So the FAI does not exclude any exhibits, even if a party would have raised such a request. This is something also that you see from the Moot problem and the FAI documents contained therein. And why it is so is that under our rules, like Article 34.1, it's clear that the issue of admissibility of evidence, that's for the arbitral tribunal to decide. And here on this topic, there's very little that I have courage to say in this Moot context. Is that in practice, what we see is that arbitrators do adopt very different approaches to issues of admissibility of evidence. And I would go as far as to say that these differences in their approach, they reflect their cultural and professional backgrounds. And as an example here, I just wanted to mention that and this might be, of course, an oversimplification, but arbitrators with a Nordic legal background may favor flexibility over more stringent and strict restrictive rules on admissibility, with the logic that such rules might prevent the arbitrators from establishing facts that the arbitrators perhaps consider relevant to deciding the dispute. Now, this was, I understand, a very, very quick overview on admissibility. And this actually brings me to the end of the presentation that I had prepared for you. And I see that there are some questions that have been popping up. So perhaps do you, Gada, want to pick and choose some of them?
Yes, we actually have one question in the chat. I will read it out loud. Does this mean that all jurisdictional objections will relate to the admissibility of the claim under the Finland arbitration rules?
So does this mean that so the jurisdictional claims, as I mentioned, they come in very different shapes and types. I mean, they can relate to different types of issues, and you can approach them differently and look them as from the viewpoint of whether a claim is admissible. But again, you can also approach the question from the point of view of the jurisdiction of a tribunal. So does that tribunal, does it in general lack jurisdiction to decide on the issue? So these are different legal concepts. So not all jurisdictional objections relate to admissibility of claims.
Okay, so we have received other questions. So the first question would be, under what circumstances do the 5 rules require parties to attempt mediation?
A very good question. The FAI rules do not expressly regulate this. I mean, there is no specific provision that would state anything on this issue, which means, again, that this is something that the arbitral tribunal then needs to decide if a party raises a claim regarding this issue.
The next question would be, does the FAI prescribe any timeline for commencing or completing the mediation process?
No, actually we don't. So the FAI does not prescribe any timelines, but the timelines are then decided between the parties and the mediator. But of course, they do keep us, or the mediator does keep us informed of the timetable or the schedule of the mediation.
Is it possible for mediation and arbitration to proceed concurrently under the FAI framework?
There is no specific rules that would prohibit these both types of procedures from being actively proceeding. But again, that's something that I would assume that the arbitral tribunal would also need to decide upon and discuss with the parties.
Now, the last question, how does the FAI ensure confidentiality during the mediation process? Would the contents of the mediation process be protected from an arbitration process, for example, as privileged statements, or would it be admissible in arbitration?
The FAI itself does not have any additional tasks related to restriction of confidentiality than those that are already in the rules. And what I perhaps mean here is that our rules do set confidentiality obligations to the parties, and then it's up for the parties to adhere to such obligations. And if a party then later is of the view that the opposing party has breached an obligation, then that's something that a party is expected to plead about if it so considers necessary for its case. And again, then it's an issue that the arbitral tribunal will need to decide when it comes to like these privileges or admissibility type of considerations.
I believe with that, our session comes to an end. So thank you very much for your time. We really appreciate it and hope to see you in Vienna.
Thank you very much. It was a pleasure, and I hope to see as many as you as possible in Vienna or in Hong Kong.